Episode 5 brings our story of the Commerce Clause up to the eve of the oral arguments before the Supreme Court on the constitutionality of Obamacare, more formally known as the Patient Protection and Affordable Care Act. In 1990, Congress passed the Gun-Free School Zone Act, making it a federal offense to possess a firearm in a school zone. In defending the act before the Supreme Court, the federal government claimed that the Commerce Clause gave Congress the power to regulate the possession of a firearm in a school zone. They offered the following argument to support their claim that such a firearm would have a substantial effect on interstate commerce. A gun in a school zone could lead to a violent crime. The cost of violent crime is substantial. This cost is spread throughout the economy via increased insurance premiums. Violent crime reduces economic activity by discouraging people from traveling to areas they consider unsafe. Guns in school zones disrupt the learning process. This leads to a less well-educated and therefore less productive citizenry. The Supreme Court found that the act was unconstitutional because it was a criminal statute that by its very terms has nothing to do with commerce or any sort of economic enterprise, however broadly one might define those terms. In its ruling, the court pointed out that under the government's national productivity reasoning, Congress could regulate any activity that it found was related to economic productivity of individual citizens. The court believed that to rule in favor of the government in this case would fundamentally change the nature of the federal government from a government of enumerated powers into one of unlimited powers, stating, thus, if we were to accept the government's arguments, we are hard-pressed to posit any activity by an individual that Congress is without power to regulate. In 1994, Congress passed the Violence Against Women Act. A section of the act gives victims of gender-motivated violent crimes the right to sue for damages in both federal and state courts. In passing the act, Congress claimed that gender-motivated violence affects interstate commerce by deterring potential victims from traveling interstate and from engaging in interstate businesses. They claim that it also affects interstate commerce by diminishing national productivity, increasing medical and other costs, and decreasing the supply of and the demand for interstate products. A woman who alleged she was the victim of a brutal sexual attack on the campus of Virginia Tech brought a lawsuit against her alleged attackers under the act. Until this suit was filed, the case had been handled entirely within the college's grievance process, not by the police or by the criminal justice system. In its ruling, the Supreme Court rejected the argument that Congress could regulate non-economic violent criminal conduct based solely on that conduct's aggregate effect on interstate commerce, and declared this section of the act unconstitutional. They held that the Constitution requires a distinction between what is truly national and what is truly local. In recognizing this fact, we preserve one of the few principles that have been consistent since the Commerce Clause was adopted. While ruling against the petitioner, the court believed her case deserved to be heard in the proper venue. If the allegations here are true, no civilized system of justice can fail to provide the petitioner a remedy, but under our federal system, that remedy must be provided by the Commonwealth of Virginia, not by the United States. Congress passed the Comprehensive Drug Abuse Prevention and Control Act in 1970. The stated goals of the act are to consolidate various drug laws into a single statute, to prevent the diversion of legitimate sources of drugs into illegal channels, and to strengthen law enforcement tools against the traffic in illicit drugs, including marijuana. The state of California enacted the Compassionate Use Act in 1996. It authorizes the local cultivation and use of marijuana for medicinal purposes. 2 California residents had been using marijuana as a medication for several years on the recommendation of their doctors. One of the physicians stated that foregoing cannabis treatments would certainly cause this patient excruciating pain and could very well prove fatal. The central question in this case was, does the Commerce Clause give Congress the power to prohibit the local cultivation and use of marijuana for medicinal purposes in compliance with California law? In its ruling, the Supreme Court acknowledged that the defendant's strong arguments that they would suffer irreparable harm if the federal government's position was upheld made this a very difficult case. but held the question before us, however, is not whether it is wise to enforce the statute in these circumstances, but rather whether or not it's within Congress's power to do so. They ruled that the Controlled Substances Act is a valid exercise of federal power, even as applied to the troubling facts of this case. The court decided that it is beyond any doubt that federal power over commerce is superior to that of the states to provide for the welfare or necessities of their inhabitants, however legitimate or dire those necessities might be. In its ruling, the court clearly defined commerce as economic activity and quoted the Webster's third new International Dictionary's definition of economics as the production, distribution, and consumption of commodities. Compare this to 1919, when Congress obviously believed that a constitutional amendment was necessary in order to prohibit the manufacture, sale, and transportation of intoxicating beverages. The foundational premise of the Constitution of the United States is that all power belongs to the people. They delegate some of that power to the states through the state constitutions. The states in turn delegate some of their power to the federal government through the U.S. Constitution. All 6 of the cases discussed in episodes 4 and 5 fundamentally address the balance of power between the federal government and the states and/or the people, with the federal government using the Commerce Clause as the primary lever to expand its share of the power. When the Supreme Court ruled in 2005 that federal power over commerce is superior to that of the states to provide for the welfare or necessities of their inhabitants, however legitimate or dire those necessities may be, it clearly demonstrates just how successful the federal power grab has been. The Commerce Clause now gives the federal government the power to forbid you to produce a product or service, even if that product or service is legal, is for personal consumption, and is never sold or given to another individual. The question now before the court, as it decides the constitutionality of the Patient Protection and Affordable Care Act, is whether or not the Commerce Clause also grants the federal government the power to force you to purchase a specific product or service. One of the arguments for mandatory health insurance is that the cost of the uninsured falls on the insured anyway, because healthcare providers, such as hospital emergency rooms, are required to treat everyone without regard to the ability to pay. Based on this argument, could the government limit the number of children you can have if larger families are more likely to require public assistance? Could they tell you what career to pursue in order to maximize overall economic growth? No decision an individual makes is free of economic impact, regardless of how trivial. If the federal government can regulate anything that affects the economy, it can regulate everything. In United States v. Lopez and United States v. Morrison, Congress and the executive branch have clearly signaled their desire to take whatever steps are necessary to exercise absolute power. In these cases, the Supreme Court finally drew a line saying, thus if we were to accept the government's arguments, we are hard-pressed to posit an activity by an individual that Congress is without power to regulate. The framers of the Constitution created a country where the federal government was a government of limited and strictly enumerated powers, and where, as guaranteed by the 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. We are on the precipice of becoming a nation where all freedoms not explicitly delegated to the people belong to the government. Power tends to corrupt, and absolute power corrupts absolutely.